Hello, my name is Martina Goertz. I'm Agile coach and project manager and work for Digital Chameleon. And I'm very happy to give you a warm welcome to the European AI regulation webinar with Professor Dr. Oliver Hase and Kai Hase from Validate ML. And in this webinar, we want to light you up regarding the impact of the European AI regulation and what this regulation means to your business. Our companies, Digital Chameleon and Validate ML, we are paired up to provide innovative and sustainable ecosystem solution. And we are very proud about this collaboration so that we can work very close together and we put our ideas and vision into practice. Professor Hase is the founder and managing director of Validate ML. He has an academic background in computer science with a focus on software engineering and verification. And his goal is it to facilitate the final and most important AI transition into the market without ignoring the safety and regulation requirements. His son and company partner, Kai Hase, he has a bachelor degree in computer science and is also fascinated by machine learning, and he is the co-founder of Validate ML. Before I hand over now to Professor Dr. Hase, I want to make you aware of the Q&A function below. There you can address your questions and we will answer the questions at the end of the webinar. So now I will hand over to Oliver. Please go ahead.
Thanks a lot, Martina, for the kind introduction. We are really excited about the partnership with Digital Chameleon on this subject matter and what's more about the overwhelming interest in this webinar. Hence, without much further ado, let's just dive right into the subject matter and talk about the European AI regulation that the European Commission has proposed this April under the name of the AI Act. And a good start to talk about this regulation is to take a first look at the aim of the AI regulation. The main aim for the European Commission was to avoid national legislation on AI regulation, but instead come up with a harmonized set of rules with the intention to increase the legal certainty for everybody who has to do with these AIs, and that's manufacturers, users, as well as the affected EU citizens. A second aim of the regulation was to define a very small set of harmful AIs whose risk is considered unacceptable and therefore will be completely prohibited under the new regulation. A third aim was to define a set of requirements that manufacturers as well as users of high-risk AIs must comply with. Fourth, the fourth aim was to define transparency rules that so-called limited risk AIs have to comply with. And the final aim was to come up with rules for an ongoing post-market surveillance to make sure that the AI systems under consideration continuously work in a compliant and safe way. When we consider the scope of the proposed regulation, it's important to differentiate between different roles. In this graphic on this map, you see icons of the actual AI systems. So the little brain icons represent AI systems. The gear wheel icons represent manufacturers or providers of these AI systems, while the person icons represent users of the system. And now what's very interesting to note in this context is that the regulation will not only affect AI systems that are deployed, used, and operated within the European Union, but also it will also affect AI systems that are deployed and used outside of the European Union if they have an impact on the health, safety, or fundamental rights of European Union citizens. This is interesting to note because it's a rather unexpected scope for European piece of legislation. At the core of the regulation is a risk-based approach. So the regulation defines four different risk categories for AI systems. These are the system with unacceptable risk, high risk, limited risk, and minimal risk. Please note that high risk and limited risk are not mutually exclusive. So a system can be both limited risk as well as high risk. The by far most interesting risk category is the high risk category. And that's why we will be discussing all of these categories in the following, and we'll be starting with the other ones first. So we'll talk about unacceptable risk, limited risk, minimal risk first, and then focus the rest of the presentation on this most important group of high risk AIs. So let's get started with the most restricted group of AIs, and these are the prohibited AIs. As I said, these are the AIs that are considered, whose risk is considered unacceptable for European Union citizens. The regulation has defined four different groups that together form these prohibited AIs. You see the first two groups, the first two definitions on this slide, and you will be seeing the other two groups on the following slide. So the first group is AI systems that use subliminal, that is subconscious techniques in order to materially distort a person's behavior, such that the system causes or can cause physiological or psychological harm. So you see, this is a rather unspecific rule exactly as to what this means, but we'll be talking about that later on. Then the second definition is the group of AIs that exploit any of the vulnerabilities of a specific group of persons due to their age, physical or mental disability. And again, if these AIs cause or can cause physical or psychological harm. An example for this second group of prohibited AIs might be, for example, a system that exploits the good faith of children to encourage them to illegal behavior, such as, for example, drug consumption or such. Then the third definition for prohibited AIs comprises public social scoring systems, but only if the consequences of these systems are used in other contexts than the observed behavior, or if the consequences are unjustified or disproportionate. Please also note that this definition is not about commercial social scoring systems, it's only about public social scoring systems. So commercial social scoring systems do not directly fall into this category. And then the fourth definition is about real-time remote biometric identification systems that are used in publicly accessible spaces for the purpose of law enforcement, except in very restricted justified cases, which means that for good reasons and for very limited time, these systems might in fact be used, might not fall under this category, but it's forbidden for public systems or for the law enforcement agencies. It's forbidden for them to establish systems like these and run them continuously. So these are the four different definitions that make up prohibited AI. Now let's move on to the next group. That's the group of limited risk AIs, and this group consists of AIs that interact with natural persons, of emotion recognition and biometric categorization systems, as well as deepfake systems. And for all these AIs, the requirement is that the affected persons need to be made aware of the existence of the AI system. That's the bottom line of this category. And as I mentioned before, this group is not mutually exclusive with the high-risk AIs that we'll be talking about later on during this presentation. Then the group number 3, or the third group, it's not group number 3, but the third group we're talking about is the group of minimal risk AIs. These are all AIs that do not fall into any of the other categories. Even though we haven't talked about high risk AIs yet, it's still the case that anything that's not considered high risk, that's not considered limited risk, and that's not considered unacceptable risk falls into this category. For these AIs, the only thing that the European Commission does or adds is that it recommends a code of conduct for the manufacturers. But it does not make any additional explicit requirements beside existing legislation, which means that if you're operating in an already regulated market, or if there's any other kind of national, European-wide, or international legislation that poses certain requirements on your system, then these still apply. There's just no other additional requirements due to the proposed AI regulation. So now, after we've talked about the 3 groups of prohibited AIs, limited risk prohibited AIs, yes, limited risk AIs, and minimal risk AIs, let's move towards the most important group, the high risk AIs. And what's interesting here is that this definition affects or contains both already regulated markets as well as not yet regulated markets. So there will be, after this, or with this regulation, there will be high risk AIs that belong into an already regulated market, and there will be high risk AIs that have not yet been regulated, but will be regulated with the new AI regulation. We will be talking about the not yet regulated markets later on. As you will be seeing, the regulation contains an explicit list of these new AIs that are considered high risk. And as I said, we'll be talking about these later, and first consider the already regulated markets now. The definition, what makes up a high risk AI in the already regulated markets, is a 2-step definition. It starts with a definition of what makes a product high risk, and then considers the AI component as a component of the product. So at first step is to determine whether the product is high risk, and then the second step is to determine whether the contained AI component is considered high risk. For the product, the rule is that every product that requires a third-party conformity assessment is considered high risk. And a third-party conformity assessment, everybody who works in a regulated market knows what that means. That means that the product will be, the conformity of the product with the regulation will be checked by an external party, of a third party, typically a notified body. So if this kind of conformity assessment is required for the product, then the product is considered high risk according to the new AI regulation. And then in the next step, in the second step, if the embedded AI component is a safety critical component of the high risk product, then the AI component itself is considered high risk. If the product is an AI or software standalone product, that means the entire product is nothing but software, then the second rule is always true, meaning that if the product is considered high risk, then automatically the AI software that makes up the product is also considered high risk. So the second rule is only applies to cases where the entire product contains something else beside the AI component. So these are rather generic rules for already regulated markets. Now, what's interesting is how to apply these rules to particular regulated markets. And as an example, we'll take a brief look at the medical devices market, because that's where we come from, where we have most expertise. And in the medical device market, the definition is that a product, a medical device product, requires third-party conformity assessment if it's classified as a 2A, 2B, or 3 device. So in this context, the definition of the requirements for third-party conformity conformity assessment boiled down to the classification of the device as I said, as a class 2A or above device. And then, as far as the second part of the rule or the definition goes, in any software component of a medical product that belongs to software safety class B or C is considered a safety critical component. If you're not from the medical device industry, then you don't really have to know how these categorization or classification rules work in the medical device industry. This is just an example of how to apply these generic rules that the AI regulation contains to particular markets. And then, of course, similar considerations need to be made for any other already regulated markets to concretize these generic rules to particular markets. Next, let's take a look at the list of already regulated markets that are affected by the new AI regulation. And this is a rather long, impressive list, starting with machinery containing toys, recreational craft, and personal watercraft, lifts and safety components for lifts, equipment and protective systems intended for use in potentially explosive atmospheres, radio equipment, pressure equipment, cableway installations, personal protective equipment, appliances burning gases, fuels, medical devices, and in vitro diagnostic medical devices. So all of these markets will be affected by the new AI regulation if they develop products that contain high-risk AIs. Now let's move to the new markets, the not yet regulated markets. As I mentioned before, the regulation contains an explicit list of AIs or application domains that will contain high-risk AIs according to the new regulation. And this list is structured in 8 application domains that I've listed here on this and the subsequent slides. The first one being biometric identification and categorization of natural persons. And that's true for real-time systems as well as systems that do the identification only after the fact. Then number 2 is safety components for critical infrastructure, including roads, water, gas, heating, electricity. The third application domain concerns education and vocational training. In this application domain, the definition comprises artificial intelligence systems that help computing or help making predictions or making proposals for the access to or the assignment to particular educational and vocational training institutions. These are systems that compute student assessments and admission assessments. Then in the fourth group is AI systems that are used in the context of employment, such as, for example, AI systems for recruitment and selection of candidates. Number 5 is the access to and the enjoyment of services and benefits. These are AI systems that compute the eligibility for public assistance benefits and services, that compute the creditworthiness of a person, or that calculate the priority for first aid response. Then number 6 is the application domain of law enforcement. In this context, in this application domain, the definition comprises AI systems for the individual risk assessment of natural persons, polygraphs and similar, or the detection of emotional state, deepfake detection, the evaluation of the reliability of evidence, profiling of natural persons, and the search for patterns and relationships in large amounts of data. Number 7 is the application domain of migration, asylum, and border control. Again, what's affected is polygraphs and similar, or the detection of emotional state. Also, the assessment of risk in terms of security, irregular immigration, and health that's posed by a person entering the European Union's territory, the verification of the authenticity of travel documents, and the examination of applications for asylum, visa, and residence. And finally, the 8th and last application domain is the administration of justice and democratic processes. Here, the AI systems that are covered by the definition are the ones that assist in researching and interpreting facts and the law, and in applying the law to a concrete set of facts. So these are the 8 application domains where the AI regulation explicitly lists as high-risk AIs, which means that whenever you develop an AI that falls under any of these 8 definitions, application domains or definitions, then you're developing a high-risk AI. Now, the next question is, if you're developing a product that's a high-risk AI, what does that mean for you? What are the requirements for the manufacturers as well as the users of these systems? A manufacturer of a high-risk AI system has to implement and use a quality management system. They also have to establish a risk management system. They have to adhere to certain data quality and governance requirements. They have to draw up a technical documentation that consists of 8 parts that are defined in the AI regulation. And the intention, the purpose of this technical documentation is to document and show compliance of all your processes and the product with all the requirements of the AI regulation. Also, and this next bullet applies to users of systems, not to manufacturers. The users of an AI system have to keep the records of the system's results, that is, its predictions or its recommendations. The system must provide a certain degree of transparency. That means it must not be a black box, but it must expose its inner workings and explain how it works. And it must provide information to the user, including information about its limitations and shortcomings. The system must a high-risk AI system must always run under human oversight. That is, it must not run completely uncontrolled, but there must always be a human who oversees, controls the system, and who is able to stop the system in the worst case. And finally, a high-risk AI system needs to provide certain levels of accuracy, robustness, and cybersecurity. This slide is basically a graphical representation of the requirements we saw on the previous two slides. It centers around the bubble that shows that says AI Ops, which stands for the operations that are used to the operations and the processes that are used to develop and maintain the high-risk AI system under consideration. And this embedding quality management system bubble denotes the quality management system that governs the ongoing quality and compliance with the AI operations, so that the AI operations can provide the required levels of data quality and so on. The quality management system contains the risk management risk management system as one of its components. And finally, the technical documentation on the left-hand side is intended, as I mentioned before, is intended to show compliance of the AI ops with the regulation. So now these are the requirements, the new requirements from the new AI regulation, which are the requirements that are true for that apply to not yet regulated markets. Now, an interesting question is how to combine these new requirements with already existing requirements in an already regulated market. And again, we'll take a look, as an example, we'll take a look at medical devices. On this slide, what you see is a combination of the new requirements that we just talked about, stemming from the AI regulation, as well as the already existing requirements from the medical device market that's regulated by the medical device regulation. And as you can see, the gray parts of this diagram show the parts that we saw on this slide before. These are the same parts, except that they have become a little bit more specific, because in the medical device industry, there is a standard that you must adhere to for quality management systems. So your quality management system must be conformed to ISO 13485, for example. Your risk management systems, there's another harmonized standard that you have to comply with. And for the technical documentation, there are requirements that are specified in the medical device regulation, as well as in standard IC 62304. And now, in addition, as far as the technical documentation goes, in addition to the already existing in the already regulated market, to the already existing requirements, you'll also have to comply to the AI regulation, which formulates certain requirements on the technical documentation, as I mentioned before. And then, as far as the AI ops go, you now, for the medical device industry, you now have to comply to all these quality requirements that we talked before, as well as the already existing quality requirements that are shown in purple. So that's basically state-of-the-art good machine learning practices is one of these requirements that are already in place for medical devices, as well as the so-called IGNB checklist, which is something that I'm not going to explain now, which is not important if you're not from the medical device industry. And if you are, you know what I'm talking about. But basically, this again is an example of how to combine already existing requirements or already existing regulation with the new requirements from the AI regulation. And similar considerations, similar combinations need to be done for any other already regulated market. Now, the AI regulation is not, or the requirements do not stop at the point in time when you put your product, when you place it in the market and put it into service. but there is still ongoing requirements that have to do with post-market monitoring. A provider of a high-risk AI system must establish a post-market monitoring system to collect ongoing performance data about the artificial intelligence system to make sure that it continuously complies to the regulation and continuously works as expected and provides results as expected at the level of quality that's expected. The post-market monitoring system must be based or must be described in a post-market monitoring plan that is a mandatory part of the technical documentation. And as a supportive measure, the European Commission has promised to provide a template for this post-market monitoring plans. That's not there yet, but will help manufacturers drawing up this piece of the technical documentation. And finally, this last slide is about conformity assessment. So when a manufacturer has built a high-risk AI system, has complied with all the requirements, has the quality management system in place, the risk management system in place, has drawn up the technical documentation, then the manufacturer is ready to place the product into the market and put it into service. And that can only be done after conformity assessment. And there is which kind of conformity assessment procedure has to be followed depends on whether the product falls into an already regulated market or a not yet regulated market. For already regulated markets, the same conformity assessment stays in place that has been there before. So the conformity assessment will be the one that's defined in the already existing regulation, but will now include the new requirements, which means that this conformity assessment will not only check the pre-existing requirements, but now also the new AI regulatory requirements. The situation is different for not yet regulated markets. For these products, and these are the ones that I listed you before in these 8 different application domains, for these products, in most cases, conformity assessment is done through internal controls. That means without the involvement of an external third party, such as a notified body. There's only one exception, and that's biometric AIs. In most cases, and then there's also, again, a finer distinction on the level of biometric AIs, which is not that relevant now. But in most cases, biometric AIs have to undergo an external assessment procedure. And what's also interesting to note is that because that the European Commission has established horrendous penalties for non-compliance with the AI regulation. And my personal assumption is that this is a motivation for manufacturers to comply with the rules in spite of a lack of external involvement in the conformity assessment. So I think these two things go hand in hand, that in most cases, the conformity assessment is done internally. And in addition to that, penalties for non-compliance are, as you can see, horrendously high, as high as up to 30 million euros or 6% of a company's annual turnover, whichever is higher. So, and this brings me to the end of the presentation, and I think we are ready for the Q&A part of this webinar.
Yeah, thanks very much for the presentation. And in the meantime, we've collected questions from the Q&A chat. and we will now answer a couple of them. So first question, if a non-European company has a non-certified AI system, is this company allowed to deploy or use its AI system in the EU? And what if the used AI is embedded inside a larger product, for example, a tool inside a software suite?
All right, so this is basically two questions in one. The first one, if I understood it right, is about whether the regulation applies to companies or products that operate outside of the European Union. And as I showed on maybe slide 2 or 3, the scope of the regulation really includes companies or products like these under the condition or the assumption that the product has the AI has an impact on European citizens with regard to their health, safety, or fundamental rights. And if that's a given, then the answer is yes. The outside company falls under the new AI regulation. So that was part one of the question. And if I remember the second part right, it was about whether the situation that the AI is part of a larger product. And the answer to this part of the question is that we saw in the rules for high risk AIs, in the definition of high risk AI, that the basic assumption always is that the AI is a component of a larger product. If this larger product is itself a software product, a huge software product, or a product including hardware of whatever kind, does not matter at all. So what matters is that on the granularity of the product is considered high risk. That's step number one. And if that, and then on step 2, if the AI component is an essential part, a safety critical component of this overall product, then the AI component is considered high risk as well. I hope this answers the question, or the two parts of the question.
Okay, thanks. So the next question is, where does AI start? Is my linear regression model now suddenly illegal?
This is a very good question also. I haven't talked about the definition of AI in the context of the AI regulation. And the interesting thing is that the AI regulation indeed provides a definition of AI. It even contains an explicit list of techniques that are considered AI. And linear regression, for example, definitely is included in this list to answer this part of the question up front. Another interesting fact is that this list is intentionally open for additions. So the European Commission has reserved the right to add to this list as technology evolves. At this point in time, the definition basically contains everything that we normally consider AI or machine learning. It even goes down to pure statistical approaches. So if you're using, as I said, pure statistical techniques that one would maybe not even consider machine learning or AI, then the AI regulation does consider it AI. So a product containing statistical approaches falls under the scope or under the AI regulation. All right, now I've talked so much, I've forgotten the exact question. Kai, can you repeat the question, please?
Yeah, let me, I was skimming through the next ones already. Give me a second. The question was, is my linear regression model now suddenly illegal, and when does AI start?
Right. Okay. So if your model is illegal, I can't tell. It really depends on whether it falls into the category of prohibited AIs. So statistical regression is considered AI, and whether your product is illegal or if it falls into the scope of the AI regulation in terms of the affected markets or whether it belongs to the explicit list of high-risk AIs. That's something I can't answer. I cannot answer without knowing the product. One final, maybe if I still have time, one final remark about these different techniques that make up AI or that are considered AI. As I said, this list can be extended as technology evolves. I think from a manufacturer's point of view, what you should always consider is the intention of the regulation. The regulation intends to prohibit or at least regulate systems, software systems that have not been possible before AI. So with machine learning, you can build applications, very powerful, innovative applications that can help a lot of people, that can heal people, that can innovate the healthcare system. But you can also build very dangerous systems. And which exact technology you're using to build these systems does not really matter that much or should not matter that much from your perspective as a manufacturer. If you're building a risky system, and if you're coming up with a new technology that allows you to build a system like this, you had better be prepared for the European Commission to include this technology into their list of AI in the future.
Okay, next one. Give me a second. Okay, so the question is, are there any restrictions or requirements on research of such kind of products? Where does research, both in academia and industry, fit into the regulation?
Very good question also. Yes, I haven't talked about that yet. So the regulation does not include research. I have not mentioned that explicitly in the beginning. That has to do with the title of the webinar that says, what does it mean for my business? We are taking the rather business-oriented perspective right now. But research is not covered, is not affected by the regulation. Only when you place a product into the market and put it into service, then we're talking about products and the applicability of the new AI regulation.
Is there any plan to introduce national authorities to oversee or handle complaints similar to data protection authorities?
Yes, there's. Yeah, yes, there is. There actually is a rather rich governance structure for AI system that the European Union or the individual countries will have to establish. That comprises national authorities, notified bodies, and whatnot. I've not listed the governance structure behind all this because I didn't find it that directly relevant for a manufacturer. But as you're asking now, yes, there will be authorities that you can direct your complaints to.
Okay, thanks. Is a mathematical proof that an AI behaves in all possible situations required to fulfill the quality assurance requirement?
Oh, sorry, I didn't quite get the question.
Okay, I think the question is, do you have to prove in some way that your AI is going to behave as planned in your product? Is that required for quality assurance?
All right. Now I get it. Okay. Yeah, this is a not only good but very broad question. Well, actually, if there are mathematical proofs that your AI behaves correctly in all cases, then please let me know. I would be very much interested. To my knowledge, there are none yet, and I very much suspect that there will ever be any. No complete proofs. There are no complete proofs for software correctness. So there's very interesting research going on, and there's partial proofs, but there are no complete proofs, not even for traditional software, let alone artificial intelligence software. But then the next question is, how do you well, if not prove, at least show enough evidence that your AI system behaves correctly. And that brings us to the area of AI and machine learning validation. So there are lots of techniques that applied together at least provide enough evidence to convince people that the system behaves correctly. So similarly, on a very high level, similarly to traditional software development, the proof is done through a combination of different tests that might even include things like code inspection. And then, of course, traditional tests. Well, for machine learning and AI, the tests are not traditional, but there are test methodologies that you can run to show the robustness of your network, to show that the accuracy of your predictions is above a certain threshold. You can show that for different for different user groups, that the for different subgroups of people that the system is applied to. So basically, it's a whole suite of different different techniques that together increase the confidence in the system. But that's a very wide field, and there is not a single silver bullet, and still a lot of research going on, and also research that at this point in time moves from research into practice, into state of the art.
I may have missed it earlier, but when are the proposed regulations scheduled to go into effect?
Well, yeah, actually, you have not missed it. I haven't said it yet. So at this point in time, it's a proposal. And as I said in the very beginning, the European Commission has proposed it this April, so not too long ago. It has not passed the European Parliament yet. It has been in the first reading, so it's in the middle of being passed. I cannot tell, I cannot forecast how long it will take for the regulation to finally be passed by the European Parliament. The Parliament has has much interest in passing the regulation because it actually initiated the European Commission's work on the regulation. So whenever the regulation will be passed, and it might be as soon as within this year, whenever it will be passed, it will take another 2 years for it to apply, which means if it's passed tomorrow, then manufacturers will have 2 years time to establish everything, to establish their processes, to draw up the technical documentation to be able to bring a product into the market. So this might sound like a lot of time, depends on your perspective, on whether you rather have a business background or a scientific background. So if you have a business background, you probably don't find that too much time. And let me assure you, it's not too much time. So participating today in this webinar, getting an idea of what it might mean for your business is certainly a good idea to be ready for the regulation when it finally applies. And as I said, this might be or is very likely to happen within the next 2 years plus any month that it takes from now until the regulation gets passed.
Okay, great. Maybe we have time for just one more question. Okay, so the rules of the AI Act seem to reference requirements during the development of AI. What if my product is already developed and maybe even deployed in the market?
Yeah, that's a good question. That has to do with the 2 years time span that I just talked about. So if it's already being developed or maybe already deployed, then it will have to comply 2 years after the regulation passes the parliament.
Okay. Thank you very much for this enlightening presentation, Oliver, and the good answers you provided. I hope it helps all of our participants to get a bigger picture or better picture of what AI regulation means to our businesses. And thank you very much.
Thanks a lot, Martina, for co-hosting, and thanks everybody for your interest and your participation. Let me end with 1 or 2 remarks. The first one is, if you're still uncertain if the AI regulation applies to you or your business, or if your AI product will be considered a high-risk AI, if you just want to have a second opinion, then please just send us a short description of your product, and we'll get back to you with an assessment on these questions. And the really final remark I want to make is about an online seminar, and I want to make this remark today already. We'll have an online seminar on October 1st on the technical documentation that's required for high-risk AIs. This seminar will give you all the details of the different parts that make up a technical documentation. It will provide you with lots of best practices and examples. So if you want to get ready for the AI regulation in time and maybe even get a competitive advantage by getting ready early, then don't miss out on the seminar. And if you decide early, you'll even get an early bird registration fee. Then for that, just send email to contact@validateml.de. And yes, then now let me thank you again for your interest, your participation, the very interesting questions. And we're looking forward to hearing back from you. See you then. Bye-bye.
Bye-bye.